Supreme Court of India Rina Kumari vs Dinesh Kumar Mahto decided on January 10, 2025 MNU/SC/0067/2025 Facts of the case. The appellant, Rina, and respondent number 1, Dinesh Kumar Mahto were married on May 1, 2014. They parted ways. Original suit was instituted by Dinesh before the Family Court, under Section 9 of the Hindu Marriage Act, 1955, for restitution of conjugal rights. Additional Family Court decreed Dinesh's suit. Rina did not abide by this decree. Rina instituted original maintenance case against Dinesh seeking maintenance under Section 125 of the Code of Criminal Procedure. Dinesh was directed to pay Rs 10,000 per month to Rina. High Court held Rina would not be entitled to maintenance. Findings of the court. The issue, presently, turns upon the applicability of Section 125, 4, Code of Criminal Procedure to the case on hand. The question as to whether noncompliance with a decree for restitution of conjugal rights by a wife would be sufficient in itself to deny her maintenance, owing to Section 125, 4, Code of Criminal Procedure. The preponderance of judicial thought weighs in favor of upholding the wife's right to maintenance under Section 125 Code of Criminal Procedure, and the mere passing of a decree for restitution of conjugal rights at the husband's behest and noncompliance therewith by the wife would not, by itself, be sufficient to attract the disqualification under Section 125, 4, Code of Criminal Procedure. It would depend on the facts of the individual case, and it would have to be decided, on the strength of the material and evidence available, whether the wife still had valid and sufficient reason to refuse to live with her husband, despite such a decree. There can be no hard and fast rule in this regard, and it must invariably depend on the distinctive facts and circumstances obtaining in each particular case. In any event, a decree for restitution of conjugal rights secured by a husband coupled with non-compliance therewith by the wife would not be determinative straightaway either of her right to maintenance or the applicability of the disqualification under Section 125, 4, Code of Criminal Procedure. The findings in the proceedings for restitution of conjugal rights, which were partly uncontested as Rina did not appear before the Family Court to adduce evidence or advance her case after filing her written statement, did not clinch the issue, and the High Court ought not to have given such undue weightage to the said judgment and the findings therein. In the process, certain crucial factors were overlooked, particularly the fact that the witnesses who appeared on behalf of Rina in the Section 125 Code of Criminal Procedure proceedings were not even cross-examined. It was clear therefrom that Dinesh did not even contest or rebut what they had stated. The fact that Rina was fully dependent on her brother was thus admitted. Further, documents were placed on record in proof of Rina's abortion in January 2015. In that regard, Dinesh's admission that he did not bear the expenditure for her treatment and her unrebutted assertion that he did not take her to the hospital or even come from Ranchi to see her were clear indicia of the pain and mental cruelty meted out to her. The fact that she was not allowed to use the toilet in the house or avail proper facilities to cook food in the matrimonial home, facts which were accepted in the restitution proceedings, are further indications of her ill treatment. Applying this standard, Dinesh's conduct in completely ignoring his wife, Rina, after she suffered the miscarriage of their child would have been the proverbial last straw adding to her suffering due to the ill treatment in her matrimonial home. She, therefore, had just cause to not return to her matrimonial home, despite the restitution decree. Further, the events thereafter, or rather, the lack thereof, is relevant. The restitution decree came to be passed on April 23, 2022. Admittedly, there was no attempt made at reconciliation after 2017. However, having secured the said restitution decree, Dinesh did nothing. He neither sought execution of the decree under Order 21 Rule 32 Code of Civil Procedure, nor did he seek a decree of divorce under Section 13, 1A, 2, of the Hindu Marriage Act, 1955. These factors, taken cumulatively, clearly manifest that Rina had more than sufficient reason to stay away from the society of her husband, Dinesh, and her refusal to live with him. Notwithstanding the passing of a decree for restitution of conjugal rights, therefore, cannot be held against her. In consequence, the disqualification under Section 125, 4, Code of Criminal Procedure was not attracted, and the High Court erred grievously in applying the same and holding that Rina was not entitled to the maintenance granted to her by the Family Court. The appeal is accordingly allowed. Dinesh, respondent number 1 herein, shall pay maintenance Rs 10,000 per month to Rina, the appellant.